The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your generally bi-weekly podcast on the federal courts of appeal. I'm Diana Simpson of the Institute for Justice, filling in for your usual host, John Ross, who is beyond redemption. With me today are Robert Everett Johnson and special guest Justin Pearson, the managing attorney of IJ's office in Miami, Florida. This week on the show, we've got four great cases to talk about, and we're just going to dive right in with talking about the Second Circuit. What happens when a defendant dies?
So this case involves a New York state senator. He was convicted of making false statements to the FBI, sort of a timely thing to be convicted for. And he died. He died while his case was on appeal. And after he had been convicted, he had paid a fine. And then the question becomes, so there's this doctrine that says that if you're convicted of a crime and your case is on appeal and you die, your conviction is voided as if it had never happened. So, there's sort of some famous cases where this has happened, but one of them being the Enron conviction. And so here, his conviction is voided because it's up on appeal. He hasn't exhausted his appeals when he dies. And so under the law, that means it's like you've never been convicted in the first place. And so the question is, well, what happens to all these fines that he paid? And what the court holds is, well, you pay these fines pursuant to your conviction. You haven't been convicted, so therefore the fines have to go back, and the state has to pay the fines back to his legal heirs.
So the government doesn't get to keep its conviction, and it doesn't get to keep its money.
Exactly. Robbed by the angel of death. But, it's an interesting holding. I think the court is a little skeptical about this whole idea that, death on appeal voids the conviction, but you could sort of debate the merits of that premise. But, the sort of underlying concept that if you haven't been convicted, the state can't take your money, that's certainly, I think, a good and sort of almost self-evident sort of idea. And it's one that the Supreme Court recently reaffirmed in a case called Nelson versus Colorado, where the IJ actually submitted an amicus brief. And in that case, the state of Colorado had said, after you're convicted and your conviction's overturned on appeal, we still get to keep your money. And the Supreme Court said, no, that's not how it works. And IJ submitted a brief because it's a question that has implications for the issue of civil forfeiture. Because in civil forfeiture, that's exactly what the government is doing. They're taking your money without convicting you in the first place. And the court in Nelson said, well, that's not okay. You can't take people's money without convicting them first, or without validly convicting them. And here in the Second Circuit, the court is applying that principle in a case where somebody died. And so the question I have is, if somebody is convicted and then dies, and then the money has to go back, how on earth can you take money with civil forfeiture when someone hasn't even been convicted in the first place? And this is just something that makes doubly clear the problems with civil forfeiture.
Perhaps the Supreme Court will answer that next.
We certainly hope so.
And I mean, what's really great about this case is it goes far outside the specific facts in terms of its usefulness. As Rob points out, it talks about Nelson versus Colorado, which was a terrific decision. And the Second Circuit in this case points out correctly that the state is not permitted to charge the accused for the privilege of having been prosecuted. I mean, that's an important principle. It's the right approach, but it's not one that the courts have always taken. Now they are, and it's great to see.
Great. Well, let's move on from the Second Circuit and move on to the Sixth Circuit, where some Michigan landowners are fighting with the government. Justin?
This is a really interesting case that touches on various parts of the Constitution, including the Fifth Amendment, the Seventh Amendment, and the 11th Amendment. Basically, the government took these people's property so that they could create a public recreational trail. The landowners decided to assert their Fifth Amendment rights to just compensation, and they wanted to assert those rights in an Article III court with a jury trial.
And to be clear, it was the federal government
That is absolutely right. Thanks, Rob. And so, when they had these Fifth Amendment claims against the federal government and tried to bring them in an Article III court, they ran up against a statutory provision created by Congress saying that all of these compensatory issues needed to be brought in a different type of court where you don't have a right to a jury trial. And so what the court deals with here is whether the Fifth Amendment actually protects your right to assert those claims for just compensation in an Article III court with a jury trial. I think it does, but the court disagreed with me. The court basically says that, and it relies on some, I would say, misguided New Deal precedent to say that the government can decide, when you get to sue it, even when it's a constitutional provision like the Fifth Amendment, that can be waived, and that the government can decide, to let you do it how it wants you to do it. I think that's the wrong approach to constitutional law, but that's what the court decided. And so ultimately, the result of this opinion is that these landowners will not get to assert their claims in an Article III court in front of a jury. They'll get to bring them, but not the way that they should have been allowed to bring them.
Yeah, what the court kind of says here is, there's this idea of sovereign immunity, that you can't sue the government for money unless the government consents. And so what the court is saying is, well, the United States could assert its sovereign immunity and you wouldn't be able to sue them at all. So they get to sort of set the terms under which they've waived their sovereign immunity. The problem with that rationale is that your Fifth Amendment right to compensation is in the Constitution in the text. Your Seventh Amendment right to trial by jury is in the Constitution in the text. The Article III requirement of a judge with life tenure is in the Constitution in the text. Whereas this idea of the sovereign immunity of the United States government, it's nowhere in the Constitution. It's nowhere in the text. There is, of course, the 11th Amendment, which talks about sovereign immunity, but it talks about the sovereign immunity of the state governments. It doesn't say anything about the U.S. government's sovereign immunity. And that's not to say that sovereign immunity doesn't exist or it should be completely thrown out the window, but if you're trying to weigh the importance of these different constitutional principles, surely all of the ones that are in the text should hang higher in the balance than this kind of quasi-made-up idea of sovereign immunity that we just imported from England because it seemed like something that was a good idea.
That's absolutely right. And you can understand the anger that these plaintiffs must feel. I mean, the right to trial by jury is a crucial right. It's one that the founders cared deeply about. And you can understand why plaintiffs fighting against the government may want to have, the amount of compensation determined by a jury instead of by a judge. They should have been allowed to do so. We'll see if they file a cert petition.
Is the Sixth Circuit alone on this issue?
They don't reference other circuits, so I think they might be. However, I will point out that in fairness to the Sixth Circuit, there is some what I would call misguided or bad precedent from the New Deal era that they rely upon. So maybe they feel that it's up to the Supreme Court to correct that precedent, and I hope they do.
This may also just be, the court that they have to go to, the Court of Claims, has been in existence since the 1850s. And so this might just be one of those instances where, it's been going on so long that everybody just assumes it must be constitutional, which, of course, is not how things work, right? There's plenty of things that have been going on for a long time that are not constitutional. And then when somebody thinks about it and challenges it, people realize, oh, yeah, we probably shouldn't have been doing that.
All right. Well, shifting gears a bit, let's head over to the Ninth Circuit. Let's head over to Nevada specifically for a traffic stop. Rob?
Yeah, so this is a case involving what's called the administrative search doctrine. So the police get a tip that there is a truck that has drugs in it. And so based on this tip that comes in to the police, they decide, well, we need to search this truck. They don't have a sufficient reasonable suspicion to actually pull them over based on the drugs. They don't have quite enough information. So what they do instead is they say, well, under the state law, we can pull the truck over in order to do a safety inspection. It's what's called an administrative search. And because all we're inspecting for is safety, to make sure that the brakes are working and all these other sorts of things are in operation, we don't have to have any reason to pull them over at all. We can just do random searches of any truck we want. And this is obviously a kind of a pretext, because what they really want to do is to find these drugs. So they do find drugs in the truck. And then the government is bringing a prosecution against the truck driver for drug running. And the question becomes, can you use this administrative search program as a complete pretext to pull somebody over when what you're really interested in is the contraband that's in the truck and not the safety of the truck? And it's particularly sharply presented here because the police officer actually is on the record as saying that it is common knowledge among the police force that this administrative search program is used as a total pretext, and that it's common knowledge that you can just use it to pull people over when you think they might have drugs, but you don't have enough evidence to actually get a warrant. Ninth Circuit says, in what is kind of a striking opinion, really, that kind of pretext is not allowed. Which is interesting because the Supreme Court has cases that have said that pretexts in the traffic stop context are allowed. So outside the administrative search context, if you're, you can pull somebody over because they have a broken taillight or they have tinted windows or things like this, and it can be a total pretext that what you really want is to search for drugs. But that is allowed. But what the Ninth Circuit says is that outside that context, in the administrative search context, it's not allowed. It's interesting for sure, and it's a good decision. It's also under the Supreme Court's law. It's definitely a reach to get there, but it's moving things in the right direction. And really, what's going on underlying this is, I think, some skepticism about this whole administrative search doctrine, where the police can just search for any reason they want without having to have any reason to pull you over. The Ninth Circuit seems to think, especially given the comments by the police officer that really cast a light into how this is used, that this whole underlying premise of the administrative search doctrine is really problematic.
I think that's all true. I think it's an interesting case for all the reasons you mentioned, Rob. One thing that I was struck by was how engaged this court was. And I think this really fascinating, well-reasoned decision where the court was willing to, push the envelope a little bit because it was a right it cared about. I think this opinion shows that courts are able to be engaged when it's a right they care about. And in my mind, there's no reason they can't do that all the time. I wish the Ninth Circuit would be engaged all the time. Sadly, they're not. Here they were, and we have a great opinion because of it.
Yeah, and one other interesting thing about this is that this does actually tie into some things that we work on here at IJ, where we litigate cases involving rental inspections, which is a similar application of the administrative search doctrine. And there, what courts are saying is, you can search somebody's apartment without having to have any suspicion that you're going to find any kind of criminal activity, just because you want to make sure that the smoke detectors are working and you want to make sure that the stove is, operable. And of course, police often use those rental inspections as a complete pretext to basically go through an entire building and search every apartment in the building for drugs or other kinds of contraband. And this decision is quite interesting because it suggests that there is, as I think we've been arguing for years, that there is a serious problem with the way that these kinds of seemingly benign inspection programs are used to invade people's privacy and to circumvent the protections of the Fourth Amendment.
All right. Well, sounds like we've got a good case coming down from the Ninth Circuit. And moving on back to the Third Circuit, where the next case in the Uber and taxi battle has emerged. Justin?
Yeah, this is the latest in a long line of battles where the taxi cabs have decided that if they can't beat them, they would sue them, or oftentimes sue the government for allowing Uber to exist. I should point out that this is an opinion marked not precedent, but it's still interesting because of the claims that were brought and because of this trend that we're seeing. Basically, the Checker Cab, a taxi company, asserted that it was unfair competition, that what Uber was doing was unfair competition and violated a Pennsylvania statute that outlaws unfair competition. The court looks at that argument and is very easily able to realize that there is no merit in it whatsoever. When you look at the statute, it does not address the types of things that the taxi companies are talking about, nor should it. The number one takeaway, whether you're talking about the unfair competition statute in Pennsylvania or you're just talking about Constitution generally, the Constitution generally and competition generally, the focus is supposed to be on what's best for consumers. Consumers get to choose what service they want to use. The government doesn't get to pick for them unless it has a really good reason. And the fact that someone is providing a better service is not unfair competition. In some ways, it reminds me of the case that we're litigating right now in New Jersey involving tombstones, where the Tombstone Dealers Association convinced the state government to pass a law saying that cemeteries or anyone who owns a cemetery can't also sell tombstones. And their logic is that it's too convenient, that they can't compete with the convenience offered to consumers. Well, the fact that consumers have an additional option, an additional convenience, that's a good thing. That's not a bad thing, and that's not unfair competition. So the court did the right thing here and quite succinctly rejected the frivolous claim brought by Checker Cab.
And we have one more case to tell you about, and though it isn't a federal case, it remains in the transportation for hire realm, and it's pretty exciting. Justin?
Well, here at the Institute for Justice, we just had a big win in state trial court in Little Rock, Arkansas, of all places. The cool thing about the case is it really illustrates both the importance of judicial engagement and the usefulness of state constitutional provisions. There in Little Rock, we represented a hardworking, great guy named Ken Leininger. He was a cab driver, and he drove for Yellow Cab for 8 years. He decided he wanted to start his own business. He did not want to be an independent contractor. He wanted to own his own taxi company. So he went and bought some hybrid taxis and started this great little business, goes to City Hall in Little Rock, applies for taxi permits, and is told that he meets all of the requirements except for the fact that Little Rock passed an ordinance saying no one's allowed to compete with Yellow Cab. Well, it turns out that the Arkansas state constitution has an anti-monopoly clause. And so we were able to go to court and win on a motion for judgment on the pleadings because we were able to combine the fact that the city had created a private monopoly with the fact that the state constitution outlaws private monopolies. And thanks to the strength of our argument and the fact that we had an engaged judge, we won. We won on our motion for judgment on the pleadings.
For the non-lawyers who are listening, filing a motion for judgment on the pleadings in a case like this is kind of an aggressive move.
It's almost unheard of.
Fair? Almost unheard of.
I mean, IJ will sometimes win on motions for judgment on the pleadings in other pillars. But to be an economic liberty plaintiff and win on a motion for judgment on the pleadings was something that we are not aware of having happened before for a very long time. I should also point out that the state Supreme Court precedent we relied on was all over half a century old as well. And so this really gave us a cool opportunity to reinvigorate a very useful provision and what had been some very useful precedent that just had not been used in a while. And so now, because of our efforts, not only has Ken won his case, but people in Arkansas have another tool at their disposal to protect their constitutional rights.
We always have a bit of cleaning up to do after we win the case, and here we've got a clip. Justin, can you tell us a little bit about it?
Sure. Well, when we won in court, the result of that was that the monopoly rule was struck down. But that still meant that Ken had to go back and reapply and show again that he met all of the other requirements to have a taxi permit in Little Rock. And so he recently had his, day before the board of directors, which is what Little Rock calls its city council, where he attempted to show them that he should receive permits. And here, I'll let Ken tell you in his own words what happened.
All right, Ken, we just left the board of directors meeting. What happened?
We won. We got the permits.
And
I'm so excited. I'm actually going to be able to legally have my business in Little Rock now.
One of the things I love about this case is the way Ken has celebrated his victory. He's celebrating by buying more taxi cabs and hiring more drivers. So thanks to this great decision, not only is Arkansas a freer place, but more jobs are being created in Little Rock.
All right, well, that concludes today's show. Thanks for listening. Until our paths cross again, this is Diana Simpson of the Institute for Justice, equipping you to get engaged.